Welcome to the Wellness Law Podcast, where wellness and the law meet for contemplation and collaboration. This podcast is brought to you by the Center for Health and Wellness Law. I am your host, Barbara Zabawa. Welcome, Attorney Oren Faircloth, to the Wellness Law Podcast. I am super excited that you have joined me today to talk about wellness law from the litigation side. So everyone, please meet Oren Faircloth. He is an attorney with Siri and Glimstad. He's actually in Connecticut, but part of their New York office. And Oren has been working on some of the tobacco surcharge lawsuits that are out there in the universe right now. So welcome, Oren.
Thank you. Thank you very much for having me. I appreciate the opportunity. Happy to speak about this kind of very exciting and new line of cases and some of the policy surrounding it.
Yeah, so let's dive in. So just as background for everyone, I'm trying to create this practice area called wellness law. And a lot of what I do is, of course, research and writing in it, but also compliance consulting in this space. But there's another side to it, which I've talked about if you've ever seen me talk about Wellness Law 101, and that's the litigation side to it, because there have been lawsuits. Even before the tobacco surcharge lawsuits, we've been talking about the lawsuits that have faced workplace wellness programs in the past, going back all the way to 2011 to the Florida case. And then 2015, there was the tripod of cases that were filed against workplace wellness programs. And then the RP got involved with the EEOC and Yale University and many others until these tobacco surcharge lawsuits were really starting to come into focus about a year ago. A lot of them were filed. Anyway, Oren has been involved with the wellness litigation aspect of wellness law. And I'm curious to know, how did you get started in litigation, and particularly with this kind of employee benefits litigation that you do? And you do plaintiff side, correct?
Correct. Yeah, I only do plaintiff's work. It started probably a few years ago. I started with a small boutique firm here in Connecticut doing ERISA, which is the Employee Retirement Income Security Act. It is the federal act that protects workers when it comes to benefits, pension benefits, 401k benefits, health benefits. So I started with that firm doing a very specific type of pension case. They were called actuarial equivalence cases. They're still going on today. Cases are still being filed. When I pivoted and came to Siri and Glimstad, that practice started to pick up a little bit, and we started exploring some other possible areas of violations. And so we came across this 2018 case. The Secretary of Labor filed a case against a major retailer, arguing that they were not complying with the rules that govern wellness programs. And from there, we started to see some cases come out afterwards. There were a few cases that popped up on the West Coast, and then we started digging in a little more, and we filed our first few cases, and then very quickly realized that this was a widespread problem, that most of corporate America, certainly the Fortune 1000, had some sort of wellness incentive program. And many of those companies, from what we've seen so far, and we're still digging in, but many of those companies are not following the rules. And we thought, not only do we have interest in bringing lawsuits to protect participants, but this is also an area that seems to be taking off, because as you have shifts politically in who's running things, budgets are being cut. And so federal enforcement agencies that could once step into this role and enforce these things, they're having their budgets cut. And so they're unable to do that. And so it leaves this gap for class action attorneys to step in and use litigation as a tool to try and persuade corporate America to start changing their practices, because there just seems to be this repeated overreach until someone slaps the hand and says enough is enough. That's how we got to the wellness cases. We have a couple dozen going right now. We're in the early stages, so we'll see.
Yeah.
But we feel
Yeah. And the retailer case that you mentioned, that was the Acosta v. Macy's case.
correct. Yeah. And it's still going on. It's still being litigated. I think at this point, they're, about 7 years in, multiple motions to dismiss. And so we'll see. Everyone got their eyes on that one too.
Yeah. I actually was surprised to learn that case was still pending. And I think I read after the Lober Bright case was decided by the U.S. Supreme Court last year that I think that there was a brief filed in relation to the Loper Bright decision, which was critical of the Department of Labor's interpretation of the tobacco surcharge incentive rules or wellness incentive rules or incentive law, I should say. And is that correct? Am I correct in my remembering that actually that brief was filed?
Yes. No, you are correct. In short, the major retailer Macy's was arguing that post Loper Bright, courts no longer had to defer to an agency's interpretation of an ambiguous statute. And they tried to bridge that into, you no longer have to listen to what the agencies have said about this area of law. And the Department of Labor came back and just made clear a single decision by the US Supreme Court cannot possibly overturn decades of clearly established substantive regulations. So sometimes you have agencies that give interpretive guidance. We think that this statute means substantive guidelines take years to process and develop, and they do studies, they do notice and comment periods. These are, for all intents and purposes, these are rules that govern this area of the law. And the judge still hasn't made a decision on the impact of Loper Bright on this vertical of cases or this line of litigation. But I'm sure judges will start to weigh in on this. Other judges around the country have said the same thing. You're reading the Loper Bright case just too broadly to say that it would undo years of established regulations.
Yeah.
And everyone's watching closely.
Yeah. So if and when a decision in that Macy's case about the impact of Loper Bright on the Department of Labor's interpretation of the wellness incentive law that from the Affordable Care Act comes out, is that going to impact your line of cases? Do you think it will impact your line of cases with the tobacco surcharge lawsuits?
I think so. I think with every decision in this line of cases, it's going to pull judges in certain directions. It's certainly going to give them the hooks that they need or that they're looking for to reach the decisions that they're trying to reach. There are some judges who will very neutrally and objectively look at everything in front of them and try and make a reasoned decision. And there are, unfortunately, other judges who come into this saying, I know where I'm going, and now I'm looking for the guideposts on how I can get there. So if a court can rule in this Macy's case regarding the impact and sort of the scope of Loper Bright, there are going to be judges out there that I think are going to use that as an opportunity to get to where they want to get to.
Yeah. So are you able to talk a little bit about some of the compliance concerns at issue in the lawsuits that you are handling?
Sure. Yeah. There are a few kind of points that I think are worth mentioning. The first one is the notion of a surcharge itself. So the statute makes pretty clear that when referencing premium differentials, so you're going to charge some participants more for health insurance than others, the statute itself uses a premium discount or a rebate. And instead of imposing a system that incentivizes wellness, a lot of these companies have interpreted that to mean we can impose surcharges. So to start just with the statutory basis, it's not clear whether or not a surcharge itself is permitted under the statute. So that's right when you open the door, that's the first thing you're confronted with is, are surcharges permissible under the statute? There's an argument, of course, of course, the other side is going to come back and say they are permissible. The statute references this absence of surcharges, and so we're actually permitted to put on surcharges. I would say there is a big difference between incentivizing healthy behavior and punishing individuals for failing to meet a health standard. So right off the bat, we challenge whether or not the surcharges themselves are permissible under the statute. Assuming that the surcharges are permissible under the statute, we then get to the idea that imposing these premium differentials is actually an exception under the statute. So we start with the broad prohibition under ERISA. You cannot charge individuals more based on a health factor. And there's an exception to that rule. If you want to do this, you can do it, but you have to strictly comply with these 5 regulatory criteria. And so what we do in the course of our litigation is we go through the criteria and we see whether or not they're complying with each one. And I'm happy to go through the criteria now.
Yeah, the five factor test, as I call it. Yeah, let's review for everyone.
Exactly. So the first one is the frequency of opportunity. In short, you have to provide participants with at least one opportunity to qualify for an avenue to not pay the surcharge, at least once every 12 months. The second is the amount that you can charge them. This has changed over the years, but currently it stands at a 50% cap. So if you're paying, for example, $100 a month for health insurance, you can't charge someone $51 for this health condition, this using tobacco. The third factor is that the program that you offer to avoid the surcharge has to be reasonably designed. It's based on a facts and circumstances evaluation. You have to look at the way that the court you have to look at the factors that are applying to that in that circumstance to determine whether or not it's unreasonable. The next one is probably the main factor that most of our cases fall under. It's the uniform treatment of participants. So in short, you have to provide all similarly situated individuals with an opportunity to qualify for what's called a reasonable alternative standard. This is, at least in my field, usually takes the form of a smoking cessation program. So if you, for example, join the Quit for Life program, that would be a reasonable alternative standard. It has to be made available, being the full reward has to be made available to all individuals who wouldn't qualify under the initial standard. In other words, non-smokers. So all people who are smokers have to be provided with a reasonable alternative standard. And then the final one is with regards to notice. So if you're going to offer participants this reasonable alternative standard, you also have to notify them of their rights to avoid the surcharge. There are these sub-requirements under the notice, what constitutes legally compliant notice. But those are the 5 factors. And the main ones for us are probably the 4th factor. So what we refer to as the full reward rule. The 5th factor, the notice rule. And then what's coming up more and more is the first factor, this frequency of opportunity, because we're starting to see, at least in a few of our cases, a scheme, the 1-year offset scheme, we're calling it, where employers will offer participants an avenue to avoid the surcharge, but it's only in the prior year for the upcoming year. So if you miss the window at the end of 2024, you're stuck paying the surcharge for all of 2025. And this raises the question of, are they being offered an opportunity at least once every year? So those are the factors that we take a look at when we're evaluating a wellness program. And we found that many employers are imposing what we would call arbitrary barriers or restrictions that kind of prevent participants from taking these off ramps to avoid paying the surcharge.
Yeah. I love what you said at the very beginning of this last exchange, which was you took a step back and said, what's the whole point of this exception that was carved out in the law to allow basically to allow discrimination against a health factor. And the exception is for wellness programs. And wellness programs, there's a presumption that the intent is to get people to be well, to improve their well-being. And so I love how you described, and I'm not going to do it as artfully as you, but this whole concept of how surcharges really are antithetical to this whole concept of trying to improve well-being. How is a surcharge an acceptable means of achieving the ultimate goal of the law? And so could you expound a little bit or repeat what you said? Because I found that really interesting.
Yeah, sure. So this has been an issue that has come up in some of the cases. As we file lawsuits, defendants file motions to dismiss, to get rid of the suit and say there's no claim. And their position is, you have to prove that our program is not compliant for your case to go forward. And we throw it back at them and say, we have to start from the assumption that this surcharge you're imposing is discriminatory because it targets people based on a health factor. And so now it really falls to you, the employer, to demonstrate your compliance with the regulatory framework. And there was an interesting case from the U.S. Supreme Court that came out in April, Cunningham versus Cornell, that touches on this. And it says, if a statute is laid out in a way where it creates an exception or an exemption, the burden can be shifted from a plaintiff to the defendant to prove their compliance. And so I think where a lot of employers are getting caught up is this idea that they, the participants, have to demonstrate to us that our program doesn't comply. But really, that doesn't make any sense, because these participants don't have access to the information that is forming the decision-making process with the employers. By shifting the burden to the employers and saying it's actually on you to show that you comply with the regulations. When it comes to these tobacco surcharges, essentially what's happening is Congress wrote a law, and you have plan administrators who are interpreting that law and then imposing their own restrictions. They're saying, instead of just making it available to anyone at any time, let's give them a deadline. Let's say they have 3 months to complete this program. And if it weren't for these class action cases, there's no one that can challenge what the administrators are doing. So they interpret the law, they impose the surcharge, they impose the restrictions. And now, at least when it comes to our cases, they're saying, and you have no right to challenge this. And to us, that would really undercuts this kind of core concept of standing that we have in America. If you're harmed, you have a right to bring a lawsuit to challenge the way that you're being harmed. And in this case, you have these people that are paying between $25, $50 up to $100 a paycheck just to get health insurance. And now they're not even allowed to challenge the charge that they're being forced to pay. The way that the statute was laid out, to me, is demonstrative of congressional intent to put the burden on the employer to show that they have to comply with this very narrow exception that allows them to discriminate against their own employees by charging them more.
And you said something about the law, to your read of the law, doesn't encompass surcharges. It encompasses discounts and something else. I'm trying to remember what you said.
And
earlier.
rebates.
And
yeah. Premium discounts and rebates. And I think there's definitely an argument to be made that if Congress had intended for employers to use this exception as a way to impose surcharges, they would have referenced surcharges. There are other areas in ERISA where Congress does use the word surcharge. And here they chose not to use that word. And taking sort of a strict textualist approach to this, if they didn't use the word surcharge, then to me, there isn't a legal basis to say that a $15 per paycheck charge on employees is the same thing as a premium discount. A premium discount would be everyone's paying exactly the same. If you don't smoke, you get a little bit more money. But to charge people, to me, there isn't a basis in the statutory language to allow for that. So that's one of the arguments that we raise in our papers and in the various cases that we have. And we'll see. I think depending on the judge that you get, if you get a judge who's very much about the text of the statute, it might hold some water. Other judges will probably read that and say, it's really just the opposite side of the same coin. Premium discount is really just a deduction, but the other sides. Hopefully it gains some traction because, again, I think there's a big difference between incentivizing healthy behavior through the use of, say, carrots and punishing those who don't meet a standard through the use of sticks. And employers across the country have almost unanimously gone the stick route.
Yeah.
Hopefully we can change that.
How would a rebate work in a tobacco use wellness program? Could you just give an illustration of how you would think a rebate would work?
Sure. Yeah. So you could do something like, if an employee makes the 3 phone calls or the 4 phone calls that they're supposed to make, they will then have an additional, they'll be given a rebate, basically a premium, a refund for achieving the goals that they're supposed to achieve, as opposed to taking the money away from them to start. And then only once they finish the whole program, you can give some of it back. This way would be, if you do A, B, and C, we will add on to your paycheck a $15 bonus. To me,
Okay.
that's there is a difference between the two. There's a difference between taking money out of someone's paycheck and giving them money back for meeting certain
Sure.
standards.
Yeah. So what is like the timeline on a lot of these lawsuits that you're involved with? Do you see them getting resolved in the next year or so?
Yeah, that's most of these lawsuits were filed end of 2024. Right now we're in July 2025. Depending on the severity of the violation, some of them are, I think, going to settle a little faster than others. We've come across plans where they explicitly state in the plan, we do not provide you with the full reward, in violation of the full reward rule. Those suits, I think, have more grounds, or defendants would have more incentive to settle the case early. Other suits, depending on whether it's like a technical notice violation, I think they're going to try and push back on litigation and try and see how far they can take it down the litigation road before they're forced to the negotiating table. I think it'll vary depending on the severity of the violations, but most of them, like most federal litigation, will probably wrap up somewhere between 18 and 36 months. It might take a little bit of time.
From now or from last year?
From when they were filed, so probably from last year. So yeah, I'd be surprised if most of them didn't wrap up by 2027, sometime then, maybe early 2028.
Do you see any of the cases coming out with an actual court opinion, like on the rules?
Yeah. So we've had about 4 published opinions now discussing the surcharge cases. There's a couple cases out of Missouri. That would be Lipari Williams, a recent case of Melberg v. Compass Group. Those are decisions that denied defendants' motion to dismiss and allowed the claims to move forward. Obviously, we think the judges came out properly on those cases. There was a fairly recent case that came out of the Eastern District of Virginia, Bokma versus Performance Food Group. That one came out the same way. And then recently, there was a case that came out at Buescher versus North American Lighting. It cut the other way, finding that the plaintiffs had not sufficiently stated a claim under the full reward rule. It allowed the plaintiffs' notice claims to go forward, but it found that this 1-year offset scheme that the plan had imposed, where it mandated that people satisfy the alternative standard in the prior year to avoid the surcharge for the upcoming year, they found that was permissible under the rules. We have filed several notices to some other courts shedding light on how the court's reasoning might be a little bit off, how they might have erred in their interpretation of the rules governing the wellness program. We'll see how that goes, but I am confident that most recent decision that did come out will serve as a basis for other courts to start maybe latching on to some ideas that are in there. We hope it doesn't happen, but It is inevitable in the litigation sphere that once a trend is set, judges tend to fall into the trends that are already set. So hopefully it doesn't pick up too much steam, and hopefully judges understand that when reading the rules that govern wellness programs in a more holistic approach, they'll see that this 1 year offset implicates several of the 5 criteria and would avoid adopting that line of reasoning.
Yeah. I want to ask you one last question. You may or may not know the answer, but it's relating, again, going back to the surcharge versus more positive reinforcement to make behavior change in the wellness context. Are you aware of any studies that researchers may have done to show whether punishment versus actual reward, positive reward, when it comes to changing behavior, one works better than the other?
So it's an interesting question. When the Department of Labor and HHS and Treasury were putting together these regulations, they did a bunch of studies on surcharges and wellness programs. More studies are coming out. Probably, I think there's a few that came out just last year. With regards to the tobacco surcharge, the studies show that it may help limit smoking, certainly in the immediate future, but long term, imposing financial penalties on participants and employees doesn't really have too large of an impact on sustainable changed behavior, given the very low attendance rates and participation rates in these wellness programs. And there was a survey that was released showing that under 20% of people are participating in these programs. So if you impose if you're an employer of 100,000 people, you impose the surcharge on 20,000 of your employees, 20% of them are going to engage with the program. And out of that 20%, a few of them won't finish. Most of them won't finish. So there are some studies showing that there might be some kind of positive impact on the health of individuals, but it's not sustainable. And
Are you
again,
specifically talking about surcharges or any kind of monetary incentive, whether it's positive or negative?
so the studies that I'm thinking about were specifically with regards to surcharges.
Okay.
They found low cost surcharges, $10 a paycheck, would have a lower impact than say $40 or $50 a paycheck, which makes sense just
Yeah.
from a logical point of view. But yeah, I think this more and more studies will come out. We'll keep our ear to the ground on what's coming out. But I think if you're trying to encourage health, hitting folks with penalties, financial penalties, is not the proper way to go.
Yeah.
I would say encouraging healthy behavior would be a way to go, but not, hey, we're going to dock your paycheck for as long as you're a smoker.
Yeah. So much of this ties back to messaging and the true intent behind the programs. So that's really important. And I think this conversation that we've had today has been so enlightening. And I think people who are involved with workplace wellness program design and implementation are going to find your comments extremely valuable. I know I have. And so I want to thank you for taking the time to talk with us today. And and I thank you for your work in wellness law.
It's my pleasure. And I'll make a tiny little plug. If anyone thinks that their rights are being violated, feel free to reach out to us. This is an issue that sort of impacts more than just smokers. And if you are concerned, please reach out and maybe we can do something.
Yeah, what's the best way to reach out to you?
You can always visit our website at SiriLLP.com. You can type Siri and Glimstad into Google, give us a search. You'll see myself and several other attorneys up on there. Feel free to send us a message, give us a call. We're happy to listen to anyone who reaches out.
Wonderful. Thank you again, and you have a terrific rest of your day.
Thank you very much. You too. Take care.
Thank you for listening to the Wellness Law Podcast. You can find more wellness law resources by visiting the Center for Health and Wellness Law website at www.wellnesslaw.com, where you can also subscribe to our newsletter and follow us on social media. Until the next episode, stay well, stay hopeful, and stay legal.